Hello and welcome to the discussion of Chapter 16. Chapter 16 really has to do with business law, and like many of our other chapters, it's just an overview. I would really like you to focus in low on three things: employment and labor law issues, contracts, and negligence. Those are probably the big three when it comes to business law issues. Of course, there are many others that could come into play, but as you're looking at the material and you're thinking about the basics of business law issues, those three topics seem to be paramount. Negligence, contracts, labor and employment law. And they are probably going to impact pretty much every business, so regardless of what level or what type of business entity you end up being employed with or engaged with, you're likely to see some of these issues come into play. Now, if you end up in certain portions of a business, say you're in sales or purchasing, you're probably going to have a lot more contract knowledge added to your skill set. And if you're in HR or payroll, you're probably going to have a lot more labor and employment law added to your skill set. And almost everybody, whether they're doing a 2-year degree or a 4-year degree, is going to get a whole business law class at some point, in which case contracts will usually take up 2 weeks, and employment law and negligence will take up a week each, along with other topics that will be covered. So one of the things that we need to do, just kind of a broad brush kind of thing, is we need to understand some of the terminology associated with the law and the legal environment, and where to look, or where to be, or how to be aware of the different things that we might need to look out for. So a lot of things that impact business come from administrative law, or from what we think of as agencies. You don't have a lot of constitutional rights issues in the business space. What you have is violations of occupational safety and health issues. You have violations or civil rights discriminations, or violations of employment laws. And most of these types of activities are part of some piece of legislative activity, which is then later enhanced and enforced by administrative agencies. So at the state level, we have OSHA, and we have the Bureau of Labor and Industries. Those are two agencies that sort of impact business issues. At the federal level, you would have the Equal Employment Opportunity Commission. You would have the Department of Labor, all of which sort of interpret larger statutory law, which is the next item, which is legislated either by the federal Congress and the President, or by the state legislature and governor. But statutory law is passed. It's usually kind of broad in scope. I think of it in some ways as being like policy. And then the administrative law agencies have to write procedures about how the law will actually be carried out and administered. And so oftentimes we look to these administrative agencies for guidance. And so I've added links to my version of the Moodle shell that has the Oregon OSHA website and the Oregon Bureau of Labor and Industries website, because they are two of the kind of key agencies that a business might interact with. So one of the other things that comes up in the chapter is torts. And so torts are basically civil disagreements or civil lawsuits. And, one of the things that businesses are sometimes frustrated with is the amount of tort action that is rendered against them. And so there's a brief discussion in the chapter of tort reform, which is this idea that maybe there should be some rule reduction or some limits put in place so that there might be less total lawsuits. And then just in general, I think it's important that you think about how the entire legal system works. Everything from legislative bodies introducing and passing law, executive branches approving those, whether they be governors or presidents, agencies interpreting those laws, writing administrative laws and rules, enforcement activities, and then also, of course, when you get into enforcement, you both have inspectors and boy, there just went blank there in terms of words. But you have police officers, you have safety officers, you have almost all agencies have some kind of enforcement situation, whether they be investigators or they may go by a variety of different titles, but they review things, and then things may end up in the court system. And so you have municipal courts and county circuit courts, state courts, and federal courts. Federal courts are broken down into districts, and so there's a whole structure to how all of this stuff works. And again, we're not interested in becoming attorneys, but we need enough knowledge in business to know when we might be getting into trouble, or when we might be getting into an area where we need to do more research, or we need to seek expert advice. And so we need to understand how the playing field is organized. Again, moving along with just terminology, we have criminal law. So you're familiar with these. If you assault somebody, or somebody commits murder, or is caught stealing stuff, those are all criminal violations. But then we also have civil law, which is this idea that when you are negligent, or you are in breach of contract, or when one party sues another for any one of the various torts that might exist, that tends to be a civil law procedure. So criminal law can be punishable by the state or by the federal government, usually in fines or incarceration. Civil law is almost always resolved with some kind of monetary sort of fulfillment of a contract, or correcting of the situation with monetary resources. Torts, again, are these civil law disputes, and they come in a whole variety of different forms. They could be labor law related, they could be discrimination related, they could be negligence related, they could be breach of contract related. All of those are potential torts. Within our criminal law, we have both felonies and misdemeanors, and you're probably aware of what those mean already, but felonies are the more serious crimes, usually punishable by, say, more than a year in jail and more significant fine amounts, and they're higher level crimes in terms of the magnitude. Misdemeanors are the lesser crimes, where the jail time is usually less than a year, and the fines are smaller. So again, just terminology that we need to become comfortable with. This is a nice table from 16.2 in the chapter, which gives some nice differences between civil and criminal law. I think probably if you don't have a lot of experience with this, those distinctions might be not entirely clear to you. And so this breaks down the parties, the purpose, who has to prove what, how the cases might be tried, and then what the penalties or sanctions might be. And I just think it's a great overview. So I would encourage you to spend a little bit of time with this particular table. Negligence, big idea. So negligence is generally, I think of it in a simple sense as you failed to live up to your responsibilities. So it's not quite that simple, because there's these criteria that have to be met, and they're the 4 on this slide right here. First of all, you have to have a duty to care for somebody, and so, or to provide some kind of care or some kind of function. So imagine that you're in healthcare, And so if you're in healthcare, then you have a duty to provide a certain level of care for a patient. And there's basically definitions of what appropriate levels of care are. A breach is when you fail to live up to whatever your responsibilities were. And these kinds of negligent things, they're not just healthcare. It could be in financial services, could be in the delivery of food services. It could be all kinds of different things. But you had a duty or a responsibility. You shirked or didn't live up to your responsibility, so you breached that. And as a result of that breach was in some way a cause of a detrimental or damaging effect on another party. And that party, in the case of a negligence case, has brought a civil tort against you because your breach caused them some harm or some difficulty as a result of your, failing to act with the appropriate duty of care. And then, once you have those three criteria, we have to show that the breach or, the person pursuing the suit has to show that the breach was the cause of the negative or detrimental effects. And usually we'll think of it as the proximate cause or the legal cause. So when all of those conditions are met, and there's a great big huge body of knowledge related to just all of the ins and outs of how a negligence case is both pursued and defended. But when you have those four criteria, that's when you're sort of looking at potential negligence cases. Contracts, which may or may not be in writing. So you can form a contract just with a handshake or verbally. You generally need two parties, so one makes an offer, one accepts the offer. The offerer and the offeree are supposed to have a mirrored or symmetrical understanding of the agreement in which they've entered into. So, just for example, I agree to sell you this used car for $1,000 and you agree to purchase this used car for $1,000. That's a mirrored offer and acceptance because both parties are on the same page. All of these contracts, whether verbal or in writing, are legally enforceable. And so that's an important idea. I think that there is this misperception sometimes that all contracts have to be in writing, and that's, it's a great best practices and it's a good idea. Certainly real estate contracts have to be in writing. Many businesses reduce their contractual obligations to writing to make it more clear and to reduce the number of disputes, but you can, and people still do indeed, engage in verbal handshake types of contracts. Here's a nice slide, figure 16.1, just sort of shows what's happening with the offerer and the offeree in the contract space. And again, review that. It's good and useful. So for a contract to exist, it's supposed to have these elements here that are on the slide before you. So we've reached an agreement. So we have this mirrored agreement between the offeree and the offerer. And generally it's thought that there's some kind of consideration. That is, there's some kind of value trading hands. Like a car for $1,000, but there's consideration, there's monetary or economic substance to the to the contract in some way. You also have to have parties that are legally able to enter into contracts, and so they have to be of majority status, 18 years of age or older, not under duress or mentally deranged or in other way incapacitated or not able to engage in a contract. And so this can be this can be something to consider, particularly if you're engaged in business activities, say with minors. You might have to do some serious thinking about how you might end up in contractual relationships with them. I'm thinking things as simple as like selling music or social media or various things where lots of minors might engage in that activity, but they generally don't achieve capacity, so they can't necessarily enter into any kinds of formal contracts. The last one on the page here, lawful object, that just means you cannot have a contract that is in violation of the law, because then the contract is voided. So we can't enter into a contract, for example, that requires you to compensate me or for you to pay me to commit some kind of crime, whether it be theft or murder or assault or something like that, or anything else that is unlawful. That tends to negate contracts because they must be for a lawful purpose. Warranties, kind of a certainly a very big idea if you're a product company. We're just going to touch on it here. You can spend a little bit more time with it in the reading, but you notice it didn't fall into my big three: labor and employment law, negligence, and contracts. So warranties, you just have these different levels or different thresholds depending upon what's happening. So you can have strict liability, when a product is hazardous or something, you may have strict liability that the product performs the way it's supposed to. For strict liability, I think about things like guns and medicine, where it's really important that they perform the way they're supposed to perform and not misfunction or not work appropriately, because that would be very problematic to the users. You can have negligence because you didn't warn people. So this is one of the reasons why so many of the products that we encounter come with all kinds of various warnings associated with them. You can have negligence because the product is not fit for what it was designed to do. So if I suppose maybe you're building a house or a structure that's going to be occupied by people, and if in the end it's uninhabitable, then you have a negligence issue because it's not living up to its design. It's not meeting its design purpose, and so that can be a potential problem. And each of these, along with negligence per se, has a slightly different definition and different tests for how you prove that the party is negligent and how you go about defending yourself because of the different criterias that come into play. This is kind of an important idea here. Principals and agents. Generally, only principals can be engaged to do contracts. And so I'm going to use the college here for an example. The college only has a handful of principals, the president, the vice president, and so they're the only ones that are sort of allowed to enter into contracts on behalf of the organization. So, and you need to do this with a corporation or with a business or whatnot. You can't have every person engaging your entity into a whole variety of contracts, and so you generally reserve contracting to the principals unless you appoint an agent. And so you've heard of insurance agents or all kinds of different, travel agents. Well, you maybe haven't heard of those because those are kind of like a thing of the past, but there's all kinds of agents in the marketplace where their job is really to be a go-between between a principal and a customer to help create contracts. And so the principal will give the agent contractual ability as part of their arrangements. And so you may have to think about in your business, whether it be a small business or a big business, who the principals are going to be and whether or not you're going to give agency to to which parties within your business or that may represent you in contractual situations. And so one of the things that you should be careful about is you should be careful about entering into contracts or striking up contractual agreements with a person when you're really not sure if they're a principal or not. So if you were to come to me and say like, well, I'd like to enter into a $2 million contract with the college, that would not be reasonable, because you really shouldn't have any indication that I represent the college at that kind of level. Certainly I have a function in the college and I have certain roles and responsibilities, but making large contracts wouldn't be one of them. And so, you need to be aware of this both as an offerer and an offeree, that this idea of agency is important in the contractual world. Generally, the remedy for contracts, money. Because that's usually what is lost, is some kind of a breach of contract. One of the parties has suffered, usually financially. You can sometimes, there can be punitive damages. This is usually kind of a rare situation when the courts will want to really make an example out of another party because they have behaved egregiously. One of the other remedies not listed here is specific satisfaction, where you actually have you sort of force the other party to live up to their side of the contract if it is possible. So if they were supposed to deliver you X and they didn't deliver you X, you may be able to ask the court to force them to deliver X. But usually there's a reason why they didn't deliver X, like they accidentally sold it to somebody else, or it was damaged, or some reason, in which case we get back to money, because it's kind of the tool that we use to fix things. Other ideas sort of in the latter part of the chapter, public law and externalities. We've already sort of dealt with that. I already mentioned that I added the Oregon OSHA website to Moodle. You may find that useful. Particularly, what you might do is you might go to both the OSHA and the BOLI websites and look at the poster pages. And those are the posters that are generally available to businesses to put in the break room. And those are decent sort of first glance summary pieces of data or information that you might find insightful. Administrative law and judicial review. This is part of the idea that I was talking about. When an agency interprets a statute written by Congress. So let's say, I'll pick on the IRS. So Congress can pass a tax law at the federal level, and then the IRS, or the Department of Treasury, the IRS is a subsidiary or a subcomponent of the Department of Treasury, they're going to interpret what Congress wrote, and then they're going to create administrative rules. If you or I or another taxpayer finds those administrative rules to be, or we feel they are inconsistent with the intent of Congress or the way Congress had written the law, then there can be judicial review of the agency's action. And so this is how, I guess, the agencies that have quite a bit of power in the economy in terms of writing rules and regulations and doing the enforcement pieces, that's how agencies are checked, I guess, or held in balance, is that when they overstepped the statute that the legislators created, then judicial review can sort of say, hey, look, you've gone a step too far, that has to be corrected. One of the things about courts in general, particularly with U.S. law, we're big fans of precedence and consistency. So this is an idea where all citizens who come with a similar type of case should receive a similar type of result, and once something is decided, then everything that sort of follows a similar fact pattern should end up with the same result. And part of the argument for why this is an important idea is it creates a predictable legal system that may be as complex and as large and as difficult as it is to get a full grasp on how the legal and regulatory environment works. This idea that it behaves and operates consistently is very helpful, because if you're a business trying to make long-term decisions, if everything was uncertain, you would you'd be concerned about deploying capital or taking risk or doing certain business transactions, because if they were all just decided in an ad hoc way, that would be very difficult for you. So this idea of precedence, which goes with the idea of common law, is a pretty important idea, and it's a fairness doctrine also, in the sense that all would-be plaintiffs and defendants, citizens, should be sort of treated the same under the law, and should in most cases arrive at the same result given the same set of circumstances. So precedence is an important idea. And that really is a sort of a rapid-fire overview of the chapter. Once again, try to zero in on the employment law issues, the contract issues, and the negligence issues within the chapter. Make sure you take it all in, and don't shy away from that business law class when it comes your direction. It'll be a class that's going to have a tremendous amount of reading in it and a tremendous amount of material, but having a grasp on the rules of the road, so to speak, can really go a long ways towards steering you clear of potential problems. You don't necessarily have to be an attorney, you don't have to be an expert, but you can, if you know enough, you can know when you're getting into something that requires more research or requires that you shy away from something, and that can keep you out of a lot of trouble in business. So thanks for joining us again, and we'll look forward to catching up with you again in the next chapter.